So again, I'm Eric Kingston with Idaho Housing and Finance Association based in Boise, Idaho. And we are hosting today's Fair Housing Basics presentation by David Penny. And up until, what was it, a couple of years ago, David, when you switched over to Tomlinson?
Yeah.
Yeah, up until then, David was in private practice as an attorney representing housing providers throughout Idaho in fair housing cases, and has a ton of experience in this area. And I've learned a lot from attending his trainings over the years and just in conversation. So glad people are joining us here. It looks like we had about 49 or 50 people pre-register for this. And so I'm anticipating we'll probably have a few people join us as we get into it. This is the Fair Housing Basics. And just want to remind folks that if you want an additional training in Fair Housing Basics or another reference, you can also check out Christina Miller's YouTube video on Fair Housing Basics, and we'll have links to that on the page for these trainings. You can find that page at fairhousingforum.org. And I'm going to go ahead and share my screen here, and that'll let you see David's slides for the day. All right. And put that in there. Okay. So without further ado, I'm going to introduce David Penny, and I'll just kind of switch to this next slide here. I want you to make sure and see this disclaimer acknowledgement that the work that goes into this is partially funded by the Department of Housing and Urban Development, and they assume that you are going to release everyone from everything forever. How's that? Is that a good disclaimer, David?
That's a good summary of it, yes.
Or a waiver, I guess, yeah. All right, David, take it away.
All right, good morning, everybody. Glad you were able to attend this. We're going to blast through fair housing and a little bit of background, bring you up to speed. The real jewel of this presentation is at the end. If we can have the time to get to the slides, I have tacked on to the end of this presentation some information on how to avoid fair housing problems and fair housing violations, steps that housing providers can take. So that's that little jewel at the end. As Eric said, there is a very good HUD presentation on the basics of fair housing that Christina Miller does. It's a YouTube video, but she does not have that jewel at the end of hers. So you're definitely in the right place. So fair housing, what is fair housing? Fair housing laws are federal, state, and local laws that prohibit housing discrimination, basically treating a person differently in a housing transaction because the person is a member of a protected class. Okay, next slide, Eric. Why is it important? One, it's the law. All housing providers with the right attitude about fair housing is we want to operate our properties and conduct our business in accordance with the law. Non-compliance is a denial of civil rights. We're talking about a very serious matter. Civil rights is in the Civil Rights Act of 1968. And housing being directly one of those areas that's addressed under the law. And then the other is non-compliance is expensive. Non-compliance is a bad business decision because businesses end up paying in a number of ways. Okay, the next slide, Eric. So who are the protected classes? And first, this slide talks about the ones under federal law. The most familiar ones certainly are race, color, religion, national origin, Sex, I'm going to come back and talk about that protected class in a minute. The two that are probably at the forefront of the law today and the hardest ones for housing providers to wrestle with are familial status and mental or physical disability. Now, race, color, religion, people have a pretty good idea of those concepts because we've grown up in an era where our history involves civil rights and certainly a push towards equality. National origin, by definition, usually involves where someone is from, immigrated from, or where their parents have come from, and then certain attributes of that natural origin, such as the language somebody speaks or their customs and rituals. And we're going to get into some examples. Sex typically means male or female. However, most recently, there is a U.S. Supreme Court case that it did not involve housing, it involved employment law. But on a 6-3 decision, the U.S. Supreme Court determined that sex discrimination also includes discrimination based upon gender identity or sexual orientation.
Oh, it looks like David's frozen there.
Same definition and protections in a housing related case. Familial status is the presence of someone under the age of 18 in a household. And then of course, mental or physical disability is someone who has a mental or physical disability as defined under the law, or someone who associates with someone who has that disability, or someone who's perceived as having that disability, whether they have it or not. So let's go to the next slide. So here are just some examples of some of the discriminatory acts that if they're based upon someone who, a member of a protected class, refusing to rent, sell, or finance, basically a denial of housing. An example here might be whether overtly or just in the decision-making process, someone doesn't want children in their apartments or in their property. So they refuse to rent or sell, don't want to show, don't want to give information, or refusing to rent or sell to someone because they don't speak English would be a national origin type of discrimination. Refusing to give information, discouraged from renting, or lying about availability. One of the things that's certainly present in the housing industry today is fair housing advocacy groups using testers to call properties, and very often they'll have one person call and present themselves as Caucasian, or they'll stop by a property or have a conversation by phone where there's no accent and see what information is made available by the housing provider to that individual. And then they'll have somebody call who maybe has broken English, has a high accent, for example, or reveal something about themselves, having children or whatever. And they look to see what information does the manager, assistant manager, or leasing agent who's talking to that individual treat them the same? Or are they curt, short, don't encourage them, basically discourage them from seeking out housing with that provider? Next example, applying different rules, privileges, standards, or qualifications, or differences in how you apply those rules. Different rules for adults, different rules for children would be, and we're going to get into that in a little bit. Certain privileges that people are aware of, for example, pools and pool usage, curfews with regard to families would be an example. The next example, a variance and eviction and providing of services. Here it would just be that if a housing provider moved to eviction of someone, for example, of a particular race, or with regard to families or persons with disabilities, whereas perhaps Caucasian families without children were given more time, more opportunity to correct matters before it became serious enough for eviction, or perhaps not evicted at all. And then making discriminatory statements. And we'll talk a little bit about advertising and marketing. That's perhaps the main focus, but it can also be just casual conversation between a manager and an applicant, or the manager and residents who reside at the property, expressing a willingness or an unwillingness to do something that's based upon someone being a member of a protected class. So let's go to the next slide. Another example, and we'll talk about this one during the course of the morning as well, and that's steering to certain housing. And very often this is the place where managers make assumptions that they think they're helping people when in fact they're not. An example would be a multi-building property where the manager has what they consider their quiet building, where they steer people without children, and then their building that they direct families to, under the assumption that families want to be with families and people without children want to be in a quiet building. Or they steer families to a building that is close to the playground under the assumption that that's where families want to be. Steering members of a particular nationality under the, this happened a lot when we had refugees arriving in Idaho. The assumption was that people of a certain ethnicity or certain nationality wanted to all be together. And so either to certain apartment complexes or to certain buildings and complexes, it was, well, we'll put all the people from Somali that are Bantu Somali in that complex or in that building based upon the assumption that they all wanted to be together. Those are examples of steering that is illegal. Harassing, intimidating, threatening, or coercing. Usually this arises in the setting of a tenant-on-tenant harassment, and whether the management enforces those rules equally to the protection of all tenants, or whether they're favoring some over others. Refusing to let a person with a disability make modifications or granting an accommodation when it's necessary to use the dwelling or enjoy living at the property. We're going to talk about this at some length as to what's required, but it's going to be the bottom line is that everybody should have that process available so that requests for modification or accommodation are processed in accordance with the law. Refusing to make reasonable changes in rules and policies. Here again, that's what an accommodation is making that changes in a rule, policy, practices, or procedures so that a person with a disability can have equal use of the dwelling. We're going to focus on those last two bullet points. Next slide. Okay, so there are various housing laws. I'm going to digress here for a minute and just mention that Idaho has a Fair Housing Act, very similar to the federal Fair Housing Act, except familial status is not recognized as a protected class. That doesn't matter. The federal law supersedes that state law. But you just need to know that it's a pretty rare circumstance, but I have seen cases brought under the state act, and those are filed with the Idaho Human Rights Commission and processed through them, whereas a federal complaint of a violation of federal law is filed with HUD and processed through HUD or through the federal courts, depending on the case. The other thing to know is that within the state of Idaho, certain municipalities have laws that make it a criminal offense for you to discriminate based upon sexual orientation or gender identity. City of Boise is one of those, I believe. Pocatello, Idaho Falls, Coeur d'Alene, Moscow. There are a number, there are about 6. I think Haley and Ketchum as well. And those are actual criminal statutes where there would be a criminal penalty. But you just need to know that if you function in those, and if you want to find out where that fine line is, you need to know what your local city ordinance actually says about that. I will tell you the best practice is you're in the business of providing housing. Make your decisions not upon someone's gender identity, sexual orientation, or any of the protected classes. Base it upon their viability and qualifications to pay their rent and abide by your rules and respect your property and the other residents. Anyway, so the Fair Housing Act, that's going to be the focus of our conversation. Also, Section 504 of the Rehabilitation Act of, I think it's 1973, protects individuals with disabilities in publicly funded housing, such as project-based Section 8 and RD properties. And then there's a lot of confusion almost always when we get down to a request for accommodation for service animals, and where that Fair Housing Act begins, where the ADA ends. And just for some basic rules here, the ADA deals with places of public accommodation. So the ADA does not apply within the threshold of an apartment. That's where the Fair Housing Act is. The ADA does apply to your rental office, to your common areas, to your clubhouse. And generally, under the most current interpretation of the ADA, is it provides for service animals, those that perform a service and are trained for that service, and 999 times out of 1,000, it's going to be a dog. Or in some cases, oddly enough, a miniature horse. But any other animal is not protected by the ADA. I will tell you that, and we're going to talk about the various differences between these animals. When it comes to the Fair Housing Act, though, you're a provider of housing services. You provide that in your rental office. You might provide that in your clubhouse. The bottom line is that I believe you have to view the Fair Housing Act as extending to all those areas at your particular property and apply it accordingly. And we're going to get into that. So next slide. So I'm going to focus now on the 2 main areas where there seems to be the most confusion, the most questions, and the by far most of the HUD complaints out there, I think, focus on disability discrimination and familial status discrimination. And first, I'm going to not follow the slide exactly, but I'm going to talk a little bit about the process to go through. And everybody should have a written process for processing requests for accommodation and requests for modifications. So the person, whether they're an applicant, whether they're a resident, making the request for an accommodation or modification can make that request verbally. The request does not have to be in writing. So instantly the manager, the maintenance staff, people need to know and be looking for that request. And sometimes the request is easy to identify because perhaps the person's disability is obvious and you can see it or determine it. Other times that disability may not be obvious. And so staff needs to have a trained ear towards someone asking for a change or a modification in a policy, procedure, or rule that would help them be able to live in the apartment complex. And then the other area that's of extreme importance is you get that request, you can have a set of documents that you would like the person to use and suggest that maybe they would want to put it in writing. Or if they don't put it in writing, then you can write it down for them to look at to get a confirmation that you've got their request correctly. And then you can offer verification forms to them, because while the request can be verbal, you can require a written verification as long as the disability and need for the disability are not obvious. So the example there is someone comes in, they're an applicant, and they have a dark sunglasses on, and they have a dog with a harness, and you observe the dog helping this person find their way into your office. That's an obvious disability with an obvious need for that animal. In that situation, no verification should be necessary. None should be asked. But someone comes in, typical case, there's no disability apparent, and they say that they have a disability and they need a comfort animal to live with them in their apartment. In that setting, you are certainly appropriate to require written verification of the disability and the need for the accommodation, a nexus or connection between their disability and what they're asking for. And so, at that point, you can require written verification, but you can't require them to use your form. In other words, they can come and bring you a letter from their doctor that, so long as it meets the requirements of a verification, you have to accept it. They can bring a prescription, a fairly recent prescription filled out, saying that you are a person with a disability under the Fair Housing Act, and you need to have your comfort animal or whatever the accommodation may be. So you get this verification back, either on your form or whatever they provide. You then need to make a decision on whether to grant it or not to grant it. And we'll get to that step here in a minute. I think I've covered this slide. So let's go to the next slide. The only thing I didn't cover there is certainly any information provided by the resident or applicant is confidential. So their accommodation request for an exception, two things that need to be established. and that is that the accommodation is necessary because of the disability, and it's necessary so that they can fully use and enjoy the housing. Go to the next slide. The tenant, there's no obligation on the part of the landlord to offer requests for accommodation. It's up to the tenant to request it. But those requests, as I mentioned, can be rather subtle, and the landlord can certainly seek clarification as to that. You know, you're telling me this, are you requesting an accommodation? And if the resident says yes, then you start your procedure. So who can you require to provide the verification? In virtually all cases, it's going to be a medical care provider or a social worker, but it just really needs to be a person. You can't require that level of verification. It needs to be a person who's in a position to know the disability and the necessity for the what's being requested. So it can be a care provider, it can be a parent requesting the the accommodation on behalf of a child. It could be, yeah, or a child request, an adult child requesting it on behalf of a disabled parent. Modifications are typically changes to the actual structure, such as construction of a ramp, removal of kitchen cabinets so that a wheelchair will fit under there and the person can access the sink or access a range, for example. The swing of doors, that type of thing are modifications. In the scope of modifications, the question is, well, who's going to pay for it? If the property is a project-based Section 8 or an RD property, then the landlord is going to pay for reasonable modifications. And the tenant won't bear any expense. In part, this is under that Section 503 that I mentioned. If the property is Section 42, tax credit property or conventional property, then it's up to the tenant to pay the cost of the modification. And then lastly, if the landlord wants the dwelling to be converted back to its original state after the tenant moves out, then that can be a requirement. Again, it'll be at landlord's expense if it's a Section 8 or RD property. Go to the next slide. Okay, reasonable modifications. We were just talking about those, so this works. So these are structural changes, whereas accommodations or changes in policies or procedures or rules. We've talked about who is obligated to pay. The housing provider, if the tenant is going to have it done, and usually if the housing provider is going to pay for it, they will take charge and have their contractor do it, and so that you have some control over the cost. If the tenant is going to make the change to the property, then a housing provider does have certain rights, and those include requiring that it be done by a licensed, bonded, competent contractor. If a permit's required for the work, it has to be permitted. And then the last thing is the end of the tenancy. The landlord in that setting can require the tenant to remove the modification. Go ahead and go to the next slide. And we've talked a little bit about verification. Whether it's an accommodation or a modification, you can require that reliable third-party written verification. As far as what the verification is targeted to depends upon whether the disability is obvious whether the need's obvious. And you cannot require a release of medical records or medical information, and you can't ask what the person's disability is. That type of information is not within the category of what a landlord can ask. Usually the proper form will ask whether the person is disabled using some definition from the Fair Housing Act. And then the second will ask the verifying party to confirm that there's a nexus or connection. Go to the next. So when can a housing provider deny the request? Well, you can deny the request if information's not provided, for example. Then you can deny it if the requested accommodation would create an undue financial or administrative burden, or granting the request would fundamentally alter the nature of the landlord's business. So an example of these would be an accommodation that the person be excused from paying all their rent when it's due, or have a grace period for paying their rent beyond what is otherwise the rule or policy of the property, without any late fee or ramification from that, or asking that the maintenance staff of the apartment complex come take out the garbage for the resident, or to provide transportation, or to check in on them and provide supervision of how they're doing because of their disability. Those are financial and administrative burdens, and also fundamentally alter the nature of the landlord's business. That's not what the landlord's business is. It's not to become a care provider for individuals with a disability. It is to provide housing. Modifications, to put in an elevator where no elevator exists. That's obviously a financial burden that would not be reasonable, but allowing, moving light switches, putting in grab bars, those very well may be reasonable modifications for a landlord to make. Roll-in showers, that type of thing. Then if you're considering the denial of an accommodation or a modification on any of those grounds, it is often better to step back and look at it and ask yourself, is there an alternative accommodation or modification that I can provide that is not a financial or administrative burden, that addresses, at least in part, the need that the applicant or the resident has. In other words, if they bring their garbage to the dumpster and have it there, but they can't put it in the dumpster, will maintenance come and do that? You might say, doesn't matter, maintenance is out and about anyway, that's no big deal. And so you would agree, to take that step. Or maybe they'll have their rent due at the right time, but can't get it to the office. And so you would agree to come and pick up their rent payment. Those are possibilities. Okay, go to the next slide. I'm just going to touch on this because this is kind of a tough area, but you need to know that guests who have service or companion animals must be allowed to bring their animals onto the property when they visit. People don't realize this, but if you have a resident who has a disability and their guests or friends have disabilities, such that they're associated with a person with a disability, then you have to accommodate those people when they come to the property. Then also the other example is, for example, a parent who has a child who's disabled, but the child doesn't live in their household. But the mother needs an accommodation for that child on the property. Then, or you're going to make a decision about some attribute of her housing that she objects to because her disabled child comes to visit. You would have to take the disability of that child into consideration because the mother is an individual associated with someone with a disability. Go to the next slide. Okay, so that's kind of in a nutshell, disability, mental, physical disability, discrimination, and the request for accommodation process. But the best thing is to have a process that you will follow so that, you know, your timing, for example, you get the verification, what's your timing? There are a lot of opinions on this. You might get a letter from a fair housing advocate saying, please respond in 3 business days. There's no requirement that you respond in 3 business days. There's some guidance. Most recently, there was guidance in January of last year that suggests 10 days is kind of the outside limit for a response. But you know, I think the best guidance is you want that process so that you will process these as soon as you can. They don't get better with time. You need to get that response out there. And it's just an area or a pitfall where you don't want to create a problem for yourself. So between 3 and 10, if you can do it quicker, do it. If there's a reason that it's taking longer, I think certainly you want to try and get it done within 7 days. Beyond 10, you might be pushing it. Although if you're having an interactive process with the person requesting it, and they're going to provide more information, or you're working on it, then I think, you know, that could push that time frame or limit out there. But then also you want to document your responses. You want to give a written response to the request for accommodation, whether you're asking an alternative or proposing an alternative, making a denial or an approval. You want to have that letter that you can use in those settings. So again, you're documenting what you do. So I'm going to move on now to fair housing for families with children. And we talked a little bit about initially, what does familial status mean? So let's go to the next slide. Okay, so it means a child under the age of 18 in the household, whether living with a parent, a legal custodian, or their designee. Covers a woman who is pregnant and people in the process of adopting or gaining custody of a child. So it doesn't have to be a actual maternal-paternal relationship with the child. They don't have to be a child that's a blood relative of either or both children. It can be somebody who's adopted. It can be a stepchild. It can be a grandparent who has legal custody of a grandchild. There's laws, for example, if a parent or parents are in military service in the state of Idaho, they can designate someone to have custody of their child in their absence. There's a legal process for that. So that's an example of a designee. Or again, anybody trying to obtain custody of a child. So let's go to the next slide. One of the areas that I think are very important are, the application of occupancy standards. Everybody's encouraged to have occupancy standards. That's a class in and of itself. People have heard perhaps of the Keating memo and a presumptive 2 persons per bedroom. I'll just tell you that is people treat it like a presumption, but you should definitely get some guidance on occupancy standards if you don't already have them, because the number of people depends upon the size of the apartment, whether there are lofts, a lot of things. But when you have that occupancy standard, you cannot be more limiting for children than adults. You've got to apply it equally and without regard to children. It's individuals, whether adult or child. And you can't draw lines. For example, you can't say that children of a certain age cannot have their own bedroom, or have to have their own bedroom and can't share a bedroom, or you can't make it based upon the gender of the children. Those are matters that are left to the parents. Let's go to the next slide. Okay, so what's prohibited? What would be familial discrimination? So let's go to the next slide. So no one may deny housing, limit access, discourage house seekers, or create different rules or fees or standards because of familial status of the household. Rentals, purchases, lending, advertising, and any other transaction in the housing industry. And even though Idaho doesn't protect familial status under its statute, the federal law, as I had mentioned before, applies. So let's go to the next slide. Does it mean the landlord must rent in all circumstances to or cannot evict any household with children? Well, no, it doesn't. Go to the next slide. Okay. You just cannot make the children the basis for different treatment. You can't refuse rental applications or evict tenants. You have to base it upon objective criteria such as, credit history, bad conduct, bad tenant history. You have to treat everybody equally in this setting, whether they have children or not. I once represented a housing provider that had an upstairs apartment with a spiral staircase, and the pickets in the railing had been installed. I don't know whether there was even a building code, but anyway, they were pretty wide apart. And the landlord, well-intentioned as she was concerned that this one gentleman applying, who would occasionally have custody of his children that were young, could slip through or fall through those pickets on the railing and get hurt. So she denied the gentleman's application for that upstairs apartment. And this was an extreme fair housing case. This actually ended up being prosecuted by the Department of Justice for familial status discrimination. In other words, if it's worthy of you to rent to someone without children, then it should be safe enough for someone with children. You can't have that unsafe condition that makes it unsafe for a family and then rent it to people without children. So go to the next slide. So can you make rules about how children should behave? Okay. So you can have health and safety rules, but here again, they need to be neutral. They should address behavior, not children. The best example of this is I remember seeing rules where it might state children are not allowed to leave their toys and bicycles on the sidewalk. Children are not allowed to be outside of the apartments after 8 p.m. Children of all the ages must be supervised by an adult member of the household. The last one being rather overreaching. Certainly it would be reasonable at some age to require that, perhaps require it on the playground, but to require a family with young teenagers that they can't be outside of the apartment without the supervision of one of their adult members of the household goes too far and discourages families from wanting to live in the apartment complex. With regard to rules, I mean, not only children, but no adult should leave their bicycle or their toys scattered on the sidewalk. So of course the corrective measure there in the rules is just to say occupants or residents shall not leave their toys or bicycles on the sidewalk. Go on to the next slide. Yeah, so we kind of talked about this, about steering, and that the example there is, let's assume the landlord has 3 apartments, 3-bedroom apartments that are have all come available, and they've advertised these apartments, and a family shows up and is interested in seeing the apartments. It's not for the manager to decide which of those 3 to show the family and to exclude one from the group because that's their quiet building, or because they think that the family's not going to want to be near the road with those young children, or they want to be closer to the playground, for example. That's an example of where a landlord cannot decide which units are better for the family. Best practice, every unit's available to everybody. Everybody gets the opportunity to apply. I mean, you can apply your occupancy policy in determining, which units to show. But here again, you need that written policy, and you need to make sure you're applying it correctly. So go to the next slide. So beyond families, now this is kind of a more general, we're stepping back and considering all of the protected classes. I think we've covered this. Cannot offer different rental terms, conditions, privileges, nor be charged extra deposit or fees because of their protected class. Extra deposit or fees, of course, relates to someone with a disability having an approved assistance animal, whether they're a service animal or a comfort animal. And basically, when you approve a request for accommodation for an animal, you're approving an exception to whatever your pet policy is, which means whereas you charge a deposit or a fee or restrict breeds or whatever, you can do that with pets, but you're granting an exception for that assistance animal, and so those type of requirements don't apply. You can't require a deposit or fees. Offering different rental terms, conditions, or privileges. I think we've probably covered that. Harassment of a tenant by an owner, manager, maintenance, or neighboring tenant because of their protected status. This has come up. Unfortunately, there are times where um, there's neighbor on neighbor harassment. I mean, if a property has a manager, owner, or maintenance person harassing somebody because of the color of their skin or their religion or they have a disability, then there's not going to be any amount of training that's going to help you. That's the most and worst type of fair housing. But if you have a neighbor who persecutes somebody in the apartment complex, we've seen it certainly with an influx of refugees. There's some people who don't like refugees in their community. And so it becomes up to the manager to do something. But if the manager lets the persecutor persecute that other person, then you're not fairly enforcing your own rules. You're discriminating, and how you enforce your rules can result in a fair housing claim actually against the manager for allowing it to happen. So as tricky as neighbor on neighbor or resident on resident harassment can be, you have to, when it's reported or somebody complains of it and you're making decisions how to handle it, you need to keep in mind there could be fair housing implications for how you do that. We talked about evictions. Here again, that's obviously the most aggressive step that involves somebody's housing, and you have to make sure that whether you're giving notices of lease violation or making that ultimate decision to evict, that you're doing it fairly to everyone without regard to their status as a protected class. And then we've talked about unreasonable restrictions on children. And I think we've covered that. Let's go to the next slide. Just a couple of questions. Can a landlord discriminate against people who do not speak English? No, that would be national origin discrimination. But if you again have, if you're managing a rural development property or Section 8 property, then you're governed by LEP requirements, limited English proficiency requirements. And in that setting, the landlord does have an affirmative obligation to resolve language differences as a barrier to housing. You have to affirmatively do something, and that something is translation of documents and interpretation of language. The kind of standard in the industry now is to have a language line interpretive service available by phone, so that if someone does not speak English or is very poor at speaking English, or has to have a child come and translate or interpret for them, or they need a document read to them in a way they understand it, you have a language line available to address it. But separate and apart from that, if LEP requirements do not apply to you, you still cannot discriminate against someone on the grounds that they don't speak English. It's actually happened where applicants are sent away because the manager says, well, I can't understand anything that you're saying. Come back when you've learned English. That's discriminatory based upon national origin. And so, ultimately in those type of conventional housing, Section 42 housing, it's up to the tenant to try and resolve that barrier. You have to be willing to work with that tenant to resolve the barrier. You have to be willing to work with an interpreter. If they need you to wait for a minute while they get someone to come and interpret for them that they bring into the office, you have to be willing to do that and try and overcome that language barrier. Let's go to the next slide. This has to do, the answer to this is yes, as long as you require the social security number from everybody. You know, this, if you're requiring it just of people who you believe are of Hispanic nationality, because you're suspicious that, you know, perhaps they've come to this country illegally, then that would be discrimination. If you require the social security number of all prospective tenants, then you're not discriminating. You're applying your rule across the board to everybody. It would not be discriminatory. Let's go to the next slide. Another area that is, you know, the subject of its own discussion is domestic violence victims. You may have heard of the Violence Against Women's Act, which is a federal law. It applies to all except for conventional housing. And it all applies to even though the name says Violence Against Women's Act, it applies to both genders. And basically, under that body of law, a victim of domestic violence can seek certain remedies, bifurcating a lease so that the perpetrator of domestic violence can be evicted. In some occasions, an emergency transfer if that property has an available unit to which they could be transferred. The consideration of that perhaps their bad credit or bad rental history is due to the fact that they were living in a household where domestic violence was being perpetrated against them. So you need to be aware of that body of law that's out there if you manage affordable housing. So separate and apart from that, though, there is the concern about disparate impact discrimination, because women are traditionally more likely to be the victims of domestic violence. So, and most properties have a zero tolerance for violence just across the board, and you have rules and regulations. But where someone, you know, particularly a woman, comes and says, you know, I need help because, you know, I'm a victim of domestic violence, and so you know, work with me on this basis. You know, don't evict me. You know, try and come up with another way for me to remedy a lease violation. It's usually a good idea to work with that person. Doesn't mean you have to let your apartment complex be destroyed or other residents to be dramatically inconvenienced, but that zero tolerance of violence may need to, you may be willing to look at a difference where there's domestic violence. And remember, this isn't a request for accommodation, because domestic violence, sex discrimination, request for accommodation is a disability concept. It doesn't apply here. So next slide. And then just a reminder that enforcement is usually, there can be an agency complaint, which is the usual way you would see a discrimination complaint. And it's filed as an administrative matter with HUD, and HUD assigns it to an investigator. And that must happen within 1 year of the act that is the basis for the discrimination claim. Or someone can bring a lawsuit directly. They don't have to bring the administrative claim to HUD first, but if they file a lawsuit, they have to file it within 2 years of the date of discrimination. So let's go to the next slide. So here again, we touched on this. I'm trying to be mindful of our time, save a little of time for questions. So I'm going to kind of run through this. The consequences if you commit fair housing, fines, a civil suit for compensatory damages and even punitive damages. You can be the subject of an injunction, years of compliance supervision from HUD. And it doesn't cost just thousands of dollars. Usually it's tens of thousands of dollars. Ignorance of the law is not a defense. I'll just leave it at that. And therefore the importance of training. Go to the next slide. Avoiding fair housing violations. I'm just here again, education, understanding what the law requires, organization, your policies and practices in writing and fair housing compliant, and then commitment, and that's making compliance constant. So go to the next slide. If you're a provider and you have staff, then make fair housing part of the hiring process. Interview employees to find out their knowledge and experience with regard to fair housing. Determine the training. This is a good place where that HUD, Christine Miller's training, it's free. Someone can watch that video online. And I would think that should be a necessary step with anybody that you hire, and make the commitment. You can make a commitment to fair housing policy part of the employee hiring packet. Go to the next slide. Screening. This is just another area when it comes to screening applicants. You can't ask questions about physical or mental disabilities. This slide's a little out of order, but basically it's saying in your policies and practices, base your decisions on whether to rent to someone on legitimate screening criteria, their credit history, bankruptcy history, rental history, prior eviction history, and if you do it carefully, their criminal history. Those are all legitimate criteria that you can look at, and keep good records of all inquiries and applications so that if you have to come back at some point in time, you can defend your decision as non-discriminatory. Let's go to the next slide. Apartment rules we've touched on. Have a core set of basic rules that don't say anything about families or children. So it talks about occupants and residents. Have them in writing, incorporate them in to be part of your lease, and then enforce them uniformly against all residents. When there's an allegation of a violation, investigate it to determine if it's true. Speak to both sides so that you're not taking or perceived to be taking one side over the other, and keep a record of the violations and your investigation. Go to the next slide. Here again, enforce them equally, and go to the next slide. Marketing. You should have fair housing posters posted in your office. If you don't have those, you can get those from the local HUD office, or you can get them directly from HUD online. If you haven't replaced those in the last 10 years, they're new ones. You should also, in Idaho, have both a English and Spanish version of those. Post-fair housing policy. That you don't discriminate based upon protected class. There's language, lots of language out there, and HUD will give that to you as well. Make sure your advertising is fair housing compliant. And bottom line there is advertise the attributes and amenities of your property. You can advertise that you have a playground, for example, but don't advertise who you're looking for as a resident. You know, young, active, single, Caucasian residents. If that's the way your advertising presents, then you might very well have a problem. It's best to show multiracial groups if you have photographs, show people with disabilities living in your community. We've talked about steering when showing apartments. And you know, the last point here is don't make assumptions about what an applicant may or may not want. Don't assume that the person with a disability wants a first-story apartment. They'll tell you if they have no interest in a second-story apartment. Or that the person without children wants the quiet building. Okay, next slide. Training, we've talked about that. That's why you're here today. IHFA has recorded a lot of trainings that myself and another attorney, Eric Stephen, have provided over the last year or so. We've mentioned the training video with HUD. There's just ongoing efforts. There's tons of training. You can read articles online. And so the opportunities are numerous. Go to the next slide. Miscellaneous points. Have your policies, procedures, and practices and monitor and review those so that they're up to date. Good record keeping. One of the things that Eric Stephen and I preach over and over is that if you find yourself on the wrong side of a HUD complaint, then the first thing the attorney is going to want to know is documentation, documentation, documentation. He said, she said arguments are always risky. We're the professionals in this industry. The managers and management companies should keep good records so that you can defend. If accused of discrimination, you can show that that is not in fact the case. And then lastly, don't be afraid to ask for help. HUD provides guidance. There's tons of HUD guidance available on the internet just by Googling it. Intermountain Fair Housing Council provides guidance, but you've got to realize they're a fair housing advocacy group, and they do everything with a view, well, I wouldn't say everything, but they do a lot of things with a view towards whether a complaint should be filed. And then knowledgeable legal representation. I can no longer provide it because I'm other than through, well, this isn't legal advice, but through this type of presentation, but attorney Eric Stephen in Spokane practices in Idaho. He is an excellent source. And with my old law firm, Kosho Humphrey, there's an attorney there, Matt Shellstraight, some of you may know, and Matt is also a good source of advice. There may be others, but those are two that I can certainly recommend. Also, Intermountain or IHFA has their fairhousing.org website that has resources available as well. Next slide should be the last one. Yeah. Okay, so we got a little time for a few questions. That's a lot of information to digest.
Okay, thank you, David. And I'm going to type the website in here. It's www.fairhousingforum.org. And you will see recordings of the recent training events there from last fall and from last month. And we'll put a recording of this session on there as well. We do have a couple questions. Can a landlord require that an emotional support cat be spayed or neutered? And then wants clarification on a tenant requesting multiple emotional support animals. I'm sure you've never heard that before.
the landlord cannot require that a assistive animal, service or comfort animal be spayed or neutered. However, you don't have to accommodate, the newly born 7 kittens. So the individual, if they produce a wealth of kittens, that would be a lease violation to have those animals there. And so, here again, it's an area, tread carefully in these areas, but technically you cannot require spayed or neutered. You can require that the animal be licensed and vaccinated in accordance with local ordinance and state law. And then the other one was multiple.
Emotional support animals.
Okay, so one way to view this is that each animal is needs to be verified separately. So usually, I mean, if somebody has the verification and let's say their physician says, this is a person with a disability under the Fair Housing Act, and they need 2 comfort animals, then it's 2 comfort animals. I mean, the most recent guidance last January made it clear that if verified, then you can have multiple animals. But if someone has, let's, for example, the verifying party verifies an animal or, her dog, Sadie, something like that, and then the person wants to have a second dog, you can require the verification of the need for the second dog in light of the first dog. And so your request, the way you would send it to the verifier is, is there a need between, Joe Jones's disability and a second animal, given that one comfort animal has already been approved. If the response to that is no, then you've got one animal sufficient, then you'd have a basis for denial. Excuse me. Usually you're going to find that they're going to verify the need for the second animal. You also have to keep in mind that a lot of people, the best example is perhaps the veteran who's come back from a foreign war, Iraq war or Afghanistan, with PTSD, as well as some type of physical disability. So their need is for 2 assistive animals. One is a service animal, perhaps a dog that helps them with mobility issues. And then the second is a comfort animal that addresses the PTSD. So certainly, and then too, you might have a household where 4 people, all with disabilities, and each of their physicians say that they need an animal. And in that case, you'd have to prove it if properly verified. Now, then everybody says, well, that's going to be a lot and that's going to take a toll on my apartment. Well, having approved animals does not exempt anyone from keeping a clean household, and not damaging the household. And so, you can't just go inspect the ones with multiple animals, but during your course of inspecting all of your apartments and keeping them all in good shape, if people with multiple animals are, causing lease violations through damage, you should pursue that like you would with anybody else.
So David, before we sign off, I'm going to share my screen again. I've got fairhousingforum.org up on my screen, and I want to just take a second and give folks a quick tour of this so you can find some of the things that David referenced. One is So first of all, we encourage you to click this waiver of liability that basically releases everyone from everything forever and acknowledges that this is not legal advice. We also have a list of topics here, and one of them is resources and links. And if you go to that page, you'll see a bunch of different resources listed for accessibility, civil rights defense, and as David referenced, Matt Shellstraight with Kosho Humphreys. We've got Eric Stephen here. He also mentioned Eric. We've got some other options here as well. And then anything on disabilities and fair housing, filing a complaint. Lots of different resources there. So, and if you have a specific question about something and you want to type that into the search field, for instance, you might want to check out visitability. And you'll see, here's some information on visitable construction, which is different from, fair housing design and construction for multifamily. This really applies to single family. We've got great information on limited English proficiency. A lot of this is the work of Gary Haynes and Associates, and he does a lot of work on LEP and language assistance plan, kind of checking that stuff out if that's something you need. And we will be putting together a session on LEP later this month, and we'll have an announcement on that coming out with our next newsletter. So stay tuned on that one. Let's see, and then lots of different options for you. So there's a glossary and definitions area. If you have questions about a specific term you've heard, or how complaints are put together, things like that. Anyway, that's an introduction to the website, and I update that and maintain that on a pretty regular basis. So if anybody has information they'd like to share in that resources and links area, go ahead, feel free to send that to me. I'll put type my email in the box here. And then if you have questions about a certificate, a training certificate, you can reach out to Christina C at ihfa.org and reach out to one of us, and we'll be glad to respond with the best answers we have. So anyway, I want to thank David. And do you have any final words, David?
Yeah, just kind of the final word is we've covered a lot of information. And what I think you should get from this presentation is a strong desire to learn more, to improve that education and documentation aspect of your work so that you're in compliance with the law, but also can defend yourself if ever called to this. But we covered a lot of information, trying to touch on all those areas, and preparation, education are certainly the key. You should dive deeper after today to make sure that your training and documentation is up to snuff.
And I think one of the things I've heard you and Eric say over and over again is this is really a process. This is not an endpoint, like you've kind of indicated here. It's an ongoing training issue, and as you have turnover in your staff, or as things shift at the national, the federal level, it's always good to keep up to date on this and look at case law, because that could change a lot of things for you.
Sure could. I mean, there's case decisions, there's guidance that's issued. And so if you're managing these properties, just like you stay up to date on, trends or rental information, the industry markets and that sort of thing, you need to stay up to date on fair housing.
Yeah. I'm going to flip back to this briefly. This is, again, the Fair Housing Forum website. And I neglected last time to scroll down and show you, we do have a page or a post for Fair Housing Month activities. This is Fair Housing Month in April. And so you'll see links to some of our upcoming trainings. And then this basically is a specific post for our fair housing trainings with links to some of the recordings we mentioned. the presentations will be available on that. Here's a recent post on neighbor hate crimes, warden memo. And so again, we just try to put current issues up there involving case law or training opportunities. So take a look at that. You can also follow us on Twitter, and we'll be updating that, and that is Fair House Forum. Oops. On Twitter. So you can check that out as well. And we do have a page on Facebook you can follow at fairhousingforum.org or Fair Housing Forum. So hope you guys stay in touch with us, and we'll be glad to have some interactive communication going forward as you have questions or suggestions. So I think that's about it. I appreciate everybody's time, particularly you, David.
Good luck, everyone.
Yeah, document everything.
Yes.
Okay. All right. Thanks again.
Thank you.
Y'all take care. Bye.